Hello. Sir, I will just give you a brief introduction, then we can begin. Okay. So for good evening, everyone. For today's session, we have Neeraj sir here with us. He's a member of Bar Council of Delhi, and sir advises startups in structuring, funding, and compliance requirements, choosing appropriate legal structures, their registration and licensing, conducting legal audits before funding or acquisition, drafting and reviewing contracts agreements, advisory on employment laws, IP and data protection, dispute resolution, and taxation. So I welcome sir for taking this session. Over to you, sir.
Thank you, ma'am, and Supreme Incubator. I hope you all can hear me and also see me. So I am a corporate lawyer, and I essentially practice in Bangalore. I'm stationed in Bangalore. I'm a partner with Singh and Associates and handle the corporate portfolio from our Bangalore office. And today, the topic for discussion is Founders Agreement and the way to go about it, the blueprint that a founder agreement should have, and what is the critical aspect or what is the importance of having a founders agreement for a startup or for that matter, any organization where different people come together to start a new venture. So I also have a PowerPoint to engage some of you in reading other than just listening to me. So the way we have structured it, I'll speak for some 20 to 25 minutes and run you through the slides, through some ideas on different clauses of founders agreement, the reasoning behind different clauses, the approaches, and also share some of the experiences, and would like then to expect questions from most of you, so that if you have any doubts, any concerns, any queries with respect to founders agreement, that can be addressed. So I'll just open the slides for everyone's benefit. So I hope you all can see the.
Yes.
Okay, great. So the fundamental question that comes is why do we need a founders agreement? Is there a legal necessity to have this? Does the Companies Act, or for that matter any other act or policy, dictate to have this founders agreement? So the simple answer is no. There's no such law or section or provision that demands you to have a founders agreement. It is generally prescribed. So it is a prescriptive document for the benefit of the founders or the partners, the promoters who are coming together with different mindsets, approaches, and with a concrete business plan. They try to arrive at, I would say, a meeting ground and then start on with their business to understand different nuances, to have mutuality of purpose, to have, so as to say, to be on the same page, the way we generally say in the business language. So it provides that platform to all the partners to throw their ideas about what they think the business to be as, what is the purpose, what is the vision, how they would want to run the business, and then agree with all the remaining partners and record that in the founders agreement, so that there is a synchronization between all the interested parties here. So the way it functions and the timeline wherein the founders agreement should typically fit is something that is very critical, very important. So when you have an idea, you first try to understand whether that has business potential or not. And the moment you understand the business potential of an idea, you try to find people who have a similar vision, who are aligned or who are interested in understanding your idea and move forward with you to implement this potential business. And then together with the people of similar understanding, you start preparing a business plan. So you start thinking as to how best the idea can be developed, how best the idea can be implemented, grown into a successful business opportunity. In that process, you also try to understand what each partner would bring to the table. What would be their roles and responsibilities? How would they be helping in managing the entity that would be created to carry this idea forward? And the best document to record that would be the founders agreement. Then you enter into a founders agreement, sign it, and make it binding for yourselves. Then you think of the initial capital that would be necessary to execute the plan, and then you incorporate the entity after taking the right consultation from the experts, be it a CA, CS, lawyer, depending on the expertise in their areas, understand the way forward in terms of compliances, regulatory, the taxation aspect, and also what you are getting into, and what would be the exit strategy if you do not want to move forward after some time. And then you start the execution of the plan. Now, if you see the scheme of things, founders agreement should ideally be executed before you even start your entity. But is that a fundamental rule? Again, that is something which should be followed, but what we have seen, or I've seen in my experience so far, that is not generally followed amongst the startup groups. So what they try to do is, once they get into the stage of implementing their business plan and setting up the entity that would effectively implement their business idea, they think of having a founders agreement in place, or an arrangement or an agreement between the founders before they invite a third party. Sometimes in their life cycle, they never had, or they never think of having any founders agreement. But this is something which is very crucial for successfully running the company without any tussle between the different partners. And how it can be handy, we'll see that in the subsequent slides. So when you try to implement the idea, it is very important to understand the regulatory process as to what kind of regulations, what kind of compliances attract when you say would want to implement the idea in the form of a company, in the form of an LLP or a proprietorship or a partnership. So that aspect should be very clear. If you would want to invite funding from outside India, then what are the hurdles? Say, like if you incorporate a one-person company, there would be restriction of getting the FDI, or will the IP that you would have in the company will not be eligible to be licensed outside India or any other jurisdiction? So what kind of strategy or regulatory aspects that needs to be taken care of is something that is very important and preliminary. You should understand the legal implications depending on the nature of business. So say if you want to start something related to agriculture, so that sector is not very open, so you'd want to understand the various nuances associated with it, and what are the legal hurdles, legal impediments, and what are the options that are legally provided to various players who would want to enter into that line of business. What would be the cost of compliance of that line of business, and what kind of entity you should have, and how the business should be structured so as to minimize the tax implication, whether in terms of direct taxation implication or GST or other indirect taxation. And the best way to do that is to engage the right consultants and seek the right counsel. It can be your CA, it can be your CS, it can be your lawyers, depending on the nature of advice that you need. If you want advisory on the numbers, on the compliances related to tax filings, then your CA would be your best counsel, best advisor, or a tax lawyer. If you want to understand the compliances, regulatory aspects, then either a CS or a corporate lawyer would be your best shot. And in order to understand the agreements, the documentation and other processes, again, a corporate lawyer would be your best consultant. So it is also very important to understand who would be the right consultant. Just a lawyer may not be the right choice, because you also need to understand what kind of lawyer the individual is. If he is an IP consultant, then he would only be equipped to advise you on the IP space. If he is not advising in the tax side, then despite being a corporate lawyer, he cannot give you the right advice in tax area. So you should be very careful while choosing the right consultant for you, so that you get the right advisory. This is very critical. Then you incorporate the terms of founders agreement into the articles of association. Now that's what you do. So most of you, if you understand the scheme in which these startup business functions, you get investments. And when you get investments, there is something called investment agreement or shareholders agreement. Now that agreement per se is enforceable against the parties, and the company also remains a party to that agreement. But what additional step parties do generally is they take out the terms of that shareholders or investment agreement and they incorporate them into the articles of association. So this happens when a third party enters into the company. Here we are talking about founders. And if they have a founders agreement, they may as well incorporate the terms into the articles. So that is something that can be done and should be done to make that a culture of the company, the ethos of the company, so that everybody is aware, it's transparent. And even third parties who have access to these articles, it's a freely available public document, so they can understand how the company is functioning. Then defining the IP, intellectual property of the company, and transferring them to the entity, it is also very crucial. And any services or products that any of the founders have individually developed should again be assigned to the entity. Now, why I'm asking or suggesting that, okay, you define your IP, transfer it to the entity, the services or products that you develop individually, you should transfer to the entity. All these aspects they enrich the company, the entity that you incorporate, because ultimately any business also requires valuation. Any business also requires its assets to function, to attract further investments or attract further business. And all these IP or services or products develop, the moment they become part of the entity, it adds to the assets of that company and the valuation increases. And it is very crucial for the parties, for the founders, to record the consent to any future transfers of their shareholding, their ownership rights to third parties who would be involved in this business at a later point of time. So these are certain critical aspects to implement the business idea that founders have. Now, when you have the idea and when you want to draft the founders agreement at any stage, it is very important to understand and discuss and align yourself towards your goals. What are the key aspects of things that you want to achieve? And why do you want to have this startup? What is the essential purpose of having this startup? What are you trying to offer which is not already there in the business scene or business environment? How different you are? What is the critical, or I would say, important aspect of this idea that will attract the attention of people? What would be the initial product or services that you would want to offer? And after the initial phase, how you're going to scale it up. So the brainstorming with respect to your business idea needs to go through all these questions with respect to all the partners so that you're aligned, you record everything in your discussions, you understand what would be the vision statement, because when you start, you may be one person, two people, or three people, or a team of five, but then you gradually start adding people, and you need to be on the same page to motivate anybody you add to your team to implement those ideas. So you need to have the vision statement to motivate those guys to work in the line and the path that you have envisioned, and you want to push them towards that path to achieve the desired goals, to achieve the purpose for which you have set up the startup. What is the value system with respect to the way you want to conduct the business, the way you want to treat your HR, the way you want to treat your customers or business counterparts? So you have to create that value system. And it also includes with respect to how you would want to interact with the government authorities. How do you want to interact or portray your startup, your business to outside world, to anybody outside your company, so that it becomes very important, because that's the image that you are giving to any third party. And it becomes very important as to how you'd want to establish that. And that idea, that how, should be very clear from day one. Sometimes it grows, the ideas, they change gradually with more experience, more exposure. But the value system should be there. The system should be there. The process should start from day one. And once you start scaling up, once you have people, and once you have their contributions in mind, okay, what are the roles and responsibilities of different people, and how they are going to contribute towards implementing this business idea and making it a successful venture, how would you measure that success with respect to each of the different functions that you have? So this aspect, the measurement of success, becomes very important, because the way you grow, the definition of success may vary, but the way people brings their skill sets, their experience, their aspects into the business changes. Their perspective changes about the business. So say if I am a marketing guy and I join a new line of business, I have no clue about that line of business. Maybe because that line of business has been started for the first time in the relevant market. So how will I design the marketing strategy for that business? So I'll start using whatever experiences I already have, whatever ideas I've gathered from my experiences in different companies and firms I've worked with. And if they work in the new organization, well and good. So the trial and error method will continue till I get the right guidance or the right formula to market the product. But if the founders have concretized their vision, because you should not be thinking in a different tangent altogether from what other partners are thinking. That, oh, I expect Neeraj to bring not only the legal expertise, but should also have the financial contribution in terms of managing the finances of the company. But Neeraj has no finances to contribute to the business. So that aspect should be very clear. That sync between the partners is very important. So it is advisable to have that in writing. And the charter document to govern business relationship. It is very important to understand as to how the charter documents, the article of association, is drafted to. So by charter document means the main or the most important document which defines the relationship between the people. So here, even though friends are coming together or people who know each other are coming together to do this business, there should be a separate document to define their business relationship, to govern their business relationship, various, all the aspects of business relationship. And it would be very important to have this. So, what aspects it should cover? So like defining the management process. What kind of organizational structure you would want to create, how people would conduct themselves in the organization, and how would you conduct yourselves as the bosses. Policies of the company, how would the company of the firm would conduct itself, what would be the policy guideline, will it be people driven, will it be process driven, how will you define the processes, will you create SOPs for everything? Will you have softwares for everything? How would you decide what cost aspect will go into each bracket? How would you phase it out? So all those things with respect to management process should be discussed, decided, thought through, and recorded. Decision making, who would take decisions? How decisions will be taken? Will you divide different departments for yourself? So if you are an MBA, would you take care of the management or administration of the business? If you are an engineer, will you only focus on developing the product? Or you would don multiple hats and take care of multiple divisions or functioning core areas of the business? How will you induct new members? And for what areas? So if you don't understand how the HR functions, you would need somebody to do that for you. And then you may guide the vision, you may give them the vision, or you may give them the guidance as to what kind of people you're looking for your organization. But then the internal processes of HR is something that you may not be aware of, or you would not want your time to go into that space. And what would be the exit mechanism? Say one of the partners would want to leave after a few months or years into this new idea, and they would want to leave because of some other priority in their lives. So what would be the ideal way of exit, a graceful exit for that partner or founder? And if that exit mechanism is not defined, or if there is a clash of opinion or vision, how would you define the dispute resolution mechanism? How will you resolve your dispute? Will you go to court? Will you want to have arbitration? Will you want to have a mediation where somebody else is sitting with you, listening to your rants, your disputes, and then helping you arrive at an amicable solution? So defining the mode of dispute resolution becomes very crucial, because most of the time you'd want to continue being friends even after you leave the business, or you have any differences while doing the business. Paving ways for future investment and growth. What kind of opportunities you'd want to create for people to invest in your company? How would you want to grow your business? How would you want to grow your company? So those ideas, those aspects should also be captured in this founders agreement. You need clarity to have this aspect from the beginning in the founders agreement. Confidentiality. How what kind of business it is, how confidentiality plays an important role in keeping your business idea in the closed circle and safeguarded from any, I would say, any leakage or disclosure outside the parties you would want to reveal. What kind of representations each party is making and what kind of warranties are they providing to each other. That becomes very important. So to have an overall understanding of all these aspects, you need to have a founders agreement. When you start drafting the founders agreement, the first aspect is to have a recital after the name. When you write the name, founders agreement, then you would want to help the reader understand the background before digging into details as to what the agreement generally contains. So you identify all the partners, partner A, partner B, who he or she is, and the individual identification aspects. So if they are, they have a PAN, mention the PAN number, their Aadhaar number, passport number, define their current residing address, the permanent address, so that you have that confidence that there is mutual KYC. So KYP, know your partner, that aspect is done. Define the product and service of the startup. What kind of product or services you would want to have in the startup. Define that aspect in the recital. What is the intention behind forming the entity? So you spell out the intention and define the business concept that you want to implement. It is very crucial to note here that where multiple parties, two or more parties, they enter into an agreement and they are under a mistake as to a matter of fact, which is very essential to the agreement. The agreement is considered void. Void as in you cannot enforce it. It is redundant. So it becomes very important that the recital records the story of the contract in such a way that it is read and interpreted in the same way to all the parties and even to a third party, the way parties had actually conceptualized that. So I shouldn't be interpreting it in a different way. It should be written in such an easy language, such an easygoing language that everybody understands it in the same way. So that is very important. Ownership, capital contributions and expenses. Now defining the basis based on the contribution of money, skill, time, continued participation, development of business concept, industry experience, what would be the percentage of ownership of each of the partners? And what would be the vesting process if there is varied percentage? So somebody may be a founder with say 1%, but there are certain vesting process defined in the founders agreement wherein gradually based on the time or continued participation, their holding may increase. So all those aspects needs to be defined in the very beginning in the ownership clauses. How and what would be the contribution of each of the founders, whether they'll contribute as equity or they would provide loan, and what would be the limitations in those contributions, and what kind of cap you would want to provide in those contributions so that you maintain the percentages of ownership for each founder. You need to define the timelines for capital infusion. So you may commit to the infusion, your contribution, but you may not define the time, and that may be detrimental to the interest of the startup. So you need to understand as to how timelines are important and timely contribution would be important. So any commitment towards capital infusion recorded in this agreement should be well thought through, and accordingly timelines should be decided and committed. How additional capital contribution would come. So all the methods of additional contribution, so you'll invite third parties to a shareholding, or you'll take loans, or whatever aspects you'd want to include, you can include in this clause. What kind of expenses you see. So you can have a separate annexure or attachment to the whole agreement as to in terms of your business plan, wherein you can spell out the expenses and how gradually you would need to increase the expenses, and how do you need to budget the functioning so that you do not fall in a trap. Future employee interest. So you may add more people in your business, and gradually, how would you want to give them a sense of ownership in the future? So that, say, there is an ESOP scheme, there is a stock schemes which you may have as a policy in your organization, so that gradually the people who have joined you from the very beginning, they also start getting sense of ownership with time and become part of the organization, not as an employee, but also as owners gradually. So that aspect is very crucial in this clause. Then we have other crucial clauses. Equity ownership and vesting. So this we already discussed. Issuance of shares, how the shares should be issued to all the people, the process, this regulatory process should be defined. What kind of restrictions you would want to have on the transfer or pledge of shares. So say one of the partners, he's having some kind of a difficulty in economic difficulty, and he wants to transfer, sell his shares to somebody else, another friend who's willing to give money to him against those shares and become part of this company. Would you allow that unhindered? Or you'd want to put certain restrictions that no partner can transfer any of his or her shares without seeking approval. So those restrictions and the ways to go ahead and actually transfer or pledge your shares should be defined in this agreement. How would the management of the entity be undertaken? So that aspect, who would be CEO, CFO, CEO, whatever designations you want to give, and ultimately the responsibilities attached to it. Now these aspects is also these aspects should be not only understood from the perspective of the management of the company, but also the corresponding legal aspects. If you are handling finances, what kind of legal consequences can be there if there is certain unwarranted act or omission from your side? Will you be considered officer in default? Are you a key managerial personnel and you will be implicated in law? Will you be tried? Will there be any penalty or there be jail term for that? What kind of consequences there can be when you become a director of a company or a shareholder of a company and or assume different managerial roles in the company? So that aspect should be very clear, because there are around 40 different laws that attracts to you the moment you become director of a company. And depending on the functioning of the company, nature of business and different roles. So it is very important to understand what are the don'ts when you become a director, and rest all can be do's. So don'ts are the crucial aspects that one should understand and accordingly design the conduct. Roles and responsibilities. It should be defined very carefully and very meticulously so that there is all the aspects is clear to all the parties who are engaged to act in a specific role. Their responsibilities are very clear, and also the corresponding liability if they do not meet those responsibilities or fulfill those responsibilities. There should be proper checks and balances, monitoring, mentoring, and review, and those can be linked to appraisals and different other aspects. And that's how it should be, and it should be very transparent. It should be there in the agreement itself. Approval process, how any decision would be approved. If one of the founders is handling finances, will he or she have complete authority on approving any finances, or will you define limits? Do you approve anything till 50,000 INR or 1 lakh INR? If it goes beyond that, then you need to discuss with all the founders. It may not be a subject matter of board discussion, but all the founders needs to understand. So these things can be discussed, defined, a process can be prescribed in the founders agreement at the initial stage, so that you keep a strict vigil on every aspect of the business. And most importantly, those aspects wherein you need to take a consolidated decision, an informed decision, and none of the partners would act weird. Remuneration and compensation. It is very important to decide and define what would be the remuneration of each of the founders, what kind of compensation they would draw month by month or year on year, what aspect or what percentage of that compensation determined and written in this agreement would they actually take out from the company, what and how much of it they would want to retain in the company, which they can take out once the entity becomes profitable. So those aspects can also be mentioned in the founders agreement. Intellectual property. So who is developing intellectual property? If there are 5 partners, 5 founders, but only 2 are working towards creating the IP, will the IP rights remain solely with them, or you'd want the IP to come to the company as well, or only to the company, and that IP would be the contribution of those 2 partners, not any money, but the other 3 partners would foot the bill. So accordingly, you need to decide as to how this IP would figure out in the overall scheme of things, and how IP should be the property of the company. Confidentiality, I already discussed how important confidentiality aspect is. And right from the stage 1, when you have business idea, even before discussing your idea with somebody, you should have an NDA in place, so that the threat or the fear of your idea being misused or used successfully by somebody else who already is sitting with the right kind of environment or money is simply thrown out. So it is very important to have the confidentiality aspect in mind, and also there in the agreement. Dispute resolution. So there are various methods of dispute resolution. You can choose the way you'd want to resolve your dispute if there is any dispute amongst the partners. So it becomes very important to define it and initiate the dispute or resolve it as and when it comes, following that process. Exit mechanism for the partner, that we already discussed. And last but not the least is the boilerplate clauses. So boilerplate clauses are the governing law clause, which law would govern your agreement. When you would want to have the dispute resolution, a mechanism to be initiated, which how would you decide jurisdiction? So say if you are in Bangalore, you would want to have the Bangalore courts to have the jurisdiction, or if one partner is in Bangalore, the other in Delhi, how would you define the jurisdiction? How would you define different other clauses like the waiver, the clauses related to force majeure, like the COVID-19 situation presented to all the businesses, the importance of force majeure, how the business was completely shut down from conducting itself, and what kind of impact it had on different ongoing businesses, ongoing contracts, wherein there was a clock sitting on the contract, and in absence of an effective force majeure clause, what kind of implications the parties of those agreements had. So it becomes very important to have minutely drafted clauses, boilerplate clauses, the standard clauses, to understand how and when they become important, they assume importance, like payment of stamp duty, or how the counterpart clause, how many original versions of the agreement you need to have, who will keep that original version. If there are 3 parties and you want to have only one original, then where that original agreement be, and how the other parties essentially have a visibility that original agreement is accessible to them as and when they want. So it becomes very important to have these aspects covered in the founders agreement. So I think with this, I end this presentation, and the forum is open for questions.
So we already got a few questions in the chat. Should I read it to you for you?
Okay, let me also open it.
Yeah, sure.
Or maybe you can start reading.
So the first question is from Samyak Jain. How do you ensure confidentiality during as well as after exit of founder? NDA and non-compete are there, but they are not foolproof. What should be done?
So can you repeat that?
Yeah.
Okay.
How do you ensure
Mhm.
confidentiality during as well as after exit of the founder?
Okay. Now,
NDA.
now I can read the question. Okay, I got it into chat. So essentially, how do you ensure confidentiality during as well as after exit of founder? Okay, NDA and non-compete are there, but they are not full proof. What should be done? Would appreciate your suggestion on this. Okay. Now this is very important to understand as to how confidentiality works. Confidentiality is something which works not only during the pendency of the contract, during the term of the contract, but you define in the contract that how it can work, continue to be operative or enforceable after 3 months or 6 months or 1 year or 3 years of the contract. So that aspect should be defined in the contract or the confidentiality agreement, depending on the nature of the confidential information. And NDA and non-compete. Now, NDA and non-compete are totally different aspects. NDA is non-disclosure agreement, so it is non-disclosure of confidential information. Non-compete is not competing with your business. So non-compete is governed under section 27 of the Indian Contract Act. And since it is a restrictive covenant, non-compete and non-disclosure both are restrictive covenant, but since disclosure of confidential aspect can be your proprietary information which is proprietary to you. It can be your trade secret, and which may or may not be IP as well. So it becomes very important from the understanding of the contract law that this aspect is exception to the restrictive covenant. So this is something which can be enforced. If you want somebody to not disclose your confidential or proprietary information, that is something that you can enforce and have a successful enforceable clause drafted in the contract. But when it comes to non-compete is something which is not generally enforceable. Why? Because it is restricting the right of livelihood. Now, there can be multiple strategies to make it enforceable, like paying a non-compete fee and minimizing the scope of non-compete so that you are not attacking the right to livelihood of the person against whom this non-compete agreement will work. So I agree, non-compete is not a foolproof strategy, but it has its own deterrent effect. But NDA is a foolproof strategy. Now, the second question that I see is, what is the best time to sign and execute a founders agreement? So this is something which we discussed. It is generally before you start your entity. So the meeting of mind and all the discussions, all the questions should be thrown to each other before you start the entity. You should have it drafted sign and execute the founders agreement? And what factors can be considered to ensure equal distribution of equity? Now, that is something that you can record in the agreement, and the equal distribution of equity depends on what each party is bringing to the table. If you want equal distribution, the contribution should also be equal, and it cannot be equal if there is unequal contribution by members.
Hello.
Hello.
Hi,
Yeah.
hi, Neeraj. Firstly, thank you so much for a very, very insightful and comprehensive explanation. I just wanted to follow up on the question, this particular question, how to divide, ensure equal distribution of equity. And as you said very rightly, that it has to be on the basis of what a founder is bringing to the table. And in terms of qualitative skills, are there any best practices for division of this? Because generally at an early stage, both the founders, in a typical scenario, don't have a lot of capital to bring. So they bring their own skill sets or experience or, just general passion for the idea. So anyway, in that case, how we can, any best practices that you've seen to distribute this?
Okay, so see, like as I said, contribution, there can be different contributions. So if I personally become partner in a startup, I don't have business experience. I'm a lawyer, right? So what I can do is I can ensure that the business functions in a proper way. The regulatory requirements, the legal requirements is met, right? I can even handle the HR functions, which is close to legal. And I can even try, and the administration aspect is something that again can be handled. But I can't be involved in product development area, in marketing, in sales, in finance, right? There I can help, support, and learn, but those cannot be my core areas. Now, what is the saving that I am doing to the entity? What aspects of the business these functions generally cover? If we have started a law firm, then it covers pretty much most of it, right? So I'll have a major stake. But if it doesn't, if it's say a manufacturing entity, you have to manufacture and sell a medical device, then my percentage will come down drastically, right? So contribution has to be seen from the importance of functionality. Plus, if I want to increase my contribution, then the other way of doing it, other than just my contribution of my skill, is through money. So you have to decide initially, based on your business plan, what is the initial seed money you need from each of the founders, and then method to evaluate how the contribution that each guy is making from his skill or her skill, how that would be measured. Okay, there are different ways of measuring those contributions, those skills as well, to understand how you can define the percentage, or at least cancel them against each other.
Right.
So the other guy is doing only engineering and I'm doing all these 5 functions. Based on the cost, you cancel each other's contribution and say, okay, your equity can be decided only on the basis of the money that you are bringing to the table, right? But that would be true if only 2 of us are partners. If there's a third guy who has no skills, who is only bringing money, and he wants to sit as a silent partner, then the story would be different. Then the equation between the 3 would be different, right? So there are different ways in which parties come together and they contribute. So it becomes very important to understand the various nuances. The specific aspects of each of these cases would be different.
Okay, noted. Thank you. We have some more questions in the chat. One is from Samyak, who's asking, can we note down all the responsibilities which should be divided among 2 co-founders? And what about functions which do not lie between any of these two founders, which may be finance or HR, who takes them up?
Yeah. So, as I said, it is important to note down all the functions, all the responsibilities amongst, say, two co-founders, three co-founders. You note it down, divide between them. Now, there not maybe, there will always be a lot of areas or functions which may not be your strengths, or areas in which you have never worked. Then you have to mutually decide as to how you'll involve a third person as an employee or as an external consultant who can help you in those functions. Because like finance, HR, they can be outsourced as well, right? You can understand that there are a lot of agencies like for example, if I talk about me, then HR is something in which we provide training to people, right? How to handle the HR functions, what kind of documents you should have in place. And uh, the every other aspect can be managed internally except for the payroll, which again, there are payroll softwares or payroll agencies uh, which can be engaged by any of the startups at a very I would say nominal rate, and they can work on this, or engage one person in the company who would undergo this training and report to one of the founders with respect to the functions, and do the entire HR or finance, or having relevant experience in finance as well as HR, and take it up. So these aspects should be defined, but at the end of the day, even if you don't have experience in those areas, since you are starting this business, you are responsible to make it successful. You need to, and this is something which you should understand, that you should not shy away from taking those responsibilities as well. But for skills, relevant skills, you would have to engage somebody from outside or employ somebody to help you out in that process, those processes. Now, the next question is, what if two founders start the company and after a few months, other founders join? And on what factors can their compensation stake be decided? Okay, so this is something we discussed, how it can be done, because this is something that would be necessary to define in the founders agreement. Because when you have defined relationship vis-a-vis each other, it will be important to also decide how you would and when you would invite a third person to join you. And when that will happen, what would be the key principles that you will follow? So why I'm telling principles? Because it is very important to understand here that whenever a third person joins, most of the time they set out the terms and conditions to join you, because they are giving you the money. So they would want a role in the management, they would want a board seat, they would want a lot of things from you, right? And they would not work as an executive director in the company. They would be on the board to just see how is board functioning. You're not taking any decision which would be detrimental to his or her interest. So it becomes very important to understand what kind of what changes will happen when you invite a third person, and how, based on the contribution that they are making, you'll decide this, the I would say the stake, the shareholding, or the percentage that you'll do away with from your own shareholding, right? And if you are bringing a third person who would also be part of the company and participate in day-to-day functioning and take salary and compensation, then in that case, the formula would be same, which you applied for yourself. But since you have already set up or brought it to some level, the shareholding of the new individual would be a bit lesser, because the valuation of the company, you already have a valuation in place. Say, even if it's 6 months or 10 months or 2 years old, you already have a valuation. You have already put in a lot of effort, your time, energy, and resources to bring it to that level, to that position. So the contribution of the new person would definitely, the compensation would be accordingly a bit lesser to what you guys have been getting. And in order to quantify that, you'll have to see the market standards based on the experience level of the person that who is coming, based on the area in which the company is operating and the scale of the company. So all these factors, they go in towards understanding the compensation of a new person who's joining the company. Now, sometimes it is not clear as to how things will unfold. How do we note responsibilities in such a case? Okay. Now, if you don't know future, you cannot predict the difficulties that you'll face later on. So you cannot write down aspects related to that. That's why you have a dispute resolution clause, because at that point of time, if you don't agree or you don't know how to deal with that situation, you'll blame each other for not attending to that situation. And then there'll be a dispute. So you have a dispute resolution clause. As far as recording responsibilities is concerned, the responsibilities would be recorded in different profiles. So say somebody is handling operations. So if two people are handling operations, two founders are responsible for operations or development, then there may be discrepancy, there may be some difference in the way they approach. Or if there is a gap, if there is a fault, if there is some new unforeseen issue that comes up, then there will be discussion or tussle. Otherwise, if you have defined everything related to operation to one person, everything related to finance and HR to second person, then that person will have to assume all the responsibilities related to that. No exception. Unless he or she is not confident to take a decision with respect to something and would want to discuss. So you can create an option wherein you provide that confidence or that extra step or support to your co-founder, that he or she can come up with those issues, discuss with other founders, and then take a informed decision, so that he or she is bringing others into that decision making, so that if that situation is new, that situation is something never tried and tested, nobody has experienced, so it will be an informed success or an informed or collective success or collective failure. And if they think that they cannot take a call, they can always go out and take outside counsel before taking a call or decision on that aspect. So that's how you can, I guess, foolproof yourself.
Hope that answered your question, Samya. If you have any follow-up, you can unmute or discuss. Okay. Does anyone else have any other questions?
Hello?
Yes, Santosh.
Yeah, I have a basic question. Suppose there are two founders are there for any startup or kind of formation of company, and basically both of them have divided who will do, and maybe agreement has also been made regarding their roles and responsibility. But after a few months or maybe after some time, if few role and responsibilities are given to some third party means maybe we have employed someone for those roles, and now they are doing those roles and they are doing well. Is it necessary to revise that agreement in which those roles were put in some on some founders previously?
Okay, so it totally depends on how the third person is coming on board. If he is coming as an employee, then of course you'll have an employment agreement in place where you'll define the terms and conditions of employment. define his or her roles and responsibilities. The moment you do that, you can have an annexure to the existing founders agreement saying that clauses XYZ of the responsibilities defined for partner A has now been given to such and such employee under the employment agreement dated so and so, right? So you can create that kind of a supplementary agreement or an annexure to the existing founders agreement, so that it is very clear that okay, these roles have now been removed from the purview of this specific founder. Though what you can additionally do is make that founder responsible, the reporting person to this new guy, so that the ultimate responsibility of those functions still stays with that founder, if that can be possible. Otherwise, if you are making somebody a third person head of certain department or certain function, then of course this exception can be carved out in the supplementary or addendum agreement of the founders agreement.
Okay, sir. Thank you.
Welcome. Any further question?
So if there are no further questions, then we shall close the session. Thank you so much, sir, for your great insight. We hope we can conduct further sessions in future with you.
Definitely. Thank you so much for having me here, and thanks to all the participants for being such wonderful listeners. And to those who asked questions, I hope I was able to address the existing concerns or any doubts that you all had. And in case you have any further question or any doubts, you can still reach out to me. My details are there with both Supreme Incubator as well as Lawyer, or you'd have seen in the presentation that I presented to you. You can reach out to me anytime. Thank you so much.
Definitely. Thank you. Thanks a lot.
Thank you.
Yes, sir.
Thank you, sir.